Hey folks, thank you for joining us. Welcome to Retirement Roadmap with Master Plan Retirement Consultants. My name is Evan, and with me as always, retirement planner Mark Fricks. Our discussions can draw from a wide range of retirement topics, and not every point will apply to every individual. Everyone has a different circumstance and situation, so what may apply to one may have no bearing on another. This is one reason seeking a financial professional can be so important. You have a plan made specifically for your needs and your life. But all that disclaimed, there is one recommendation that is the most important for every single adult person: an up-to-date estate plan. Regardless of how low the probability is that you'll need your estate plans today, there is a 100% chance you'll need them at some point, and that point is unknown. If you don't know where to start, today's discussion will outline some vital points that require your attention. So Mark, we already have discussed in the past the importance of an estate plan. How many complete estate plans do we see come across our desks with new clients, would you say?
You know, what we mostly see are really, really old documents.
Yes.
So many people get their documents done like when they have children, and then they come in here, they're age 50 or 55 or whatever, and I mean, they're just, would they work? Maybe, but probably not the way they'd want them to work, especially when it comes to powers of attorney and healthcare directives, because those have aged out, the laws have changed. But yeah, they come in with this 2-page will from 1982 or whatever, and it's just one of those things that's so easy to put off. You don't want to think about what they mean. It's on your list or whatever. But that's mostly what we see. Maybe 20% don't have anything, but quite a few people just have really old documents.
I just came across a new client's will, and it was made in the 80s, and 50% of their heirs are no longer living within that will. So that's something that's certainly.
And maybe your backup executors might be gone as well,
right.
Or the spouse or whatever. So it really, and the problem is it gets tied up in court.
Right.
We'll talk about that someday as well. But you get tied up in probate. It comes down to judges' decisions. It comes down to state law, and it can really. I love it what you say is the greatest gift you can leave your family are complete documents. They're updated and properly,
right.
properly executed. So
yeah. Well, that brings us to the first bare minimum, and that would be Advance Directives as an estate planning priority. This is basically a combination of a healthcare power of attorney and a living will.
Right, and you need one state specific. So whatever state you're living in, it needs to be based on that state's laws. This is not a federal form. This is a state form. And so as we talk about, there's actually 3 sections to this form, at least in Georgia. Again, this could vary, but primarily the most important sections, number 1, is who's going to make your healthcare decisions if you can't communicate, okay? Whether it's a long-term situation, whether it's a short-term, maybe I've been in an accident or whatever, and they need to do surgery. That is not an automatic spouse decision. And so you really need to have that paperwork together. And if you spend time in more than one state, maybe you live in Florida half the year and Georgia half the year, you should have one for both states as well, because again, the laws are different. Section 2 is what I call the unplug me part. So it's the living will. How do you want to be treated in the last days? How do you want to be kept alive or not kept alive? What machines, things like that. And so this is language that is frequently changes because of technology. What they could have done 20 years ago, they can do so much more now, perhaps. But so you have to be very careful how you word this. The document in Georgia and most states is actually very fluid. In Georgia, it does not even have to be notarized. And you can actually go back and add language, things of that nature. So that's part 2, and part 3 is guardianship. So what happens the very final days and after you pass away? Who's in charge of your person? Funeral home arrangements, things of that nature. Who can authorize an autopsy and things of that that go along with that. So that's the 3 parts that you need to have, and. It's important that you have someone, whether it be your spouse or whoever the backup may be, to make those decisions that can do it in a way that's not too emotional. Because these are your wishes you're putting down. You want those wishes honored. You don't want somebody coming in panicking and changing stuff and things of that nature. So you want them to be somebody that can be cool-headed in a emergency situation, and it doesn't hurt to have a medical background. It's not required, but it doesn't hurt.
Well, And that being said, these can be difficult decisions to make for yourself, period. But then to think about not having these in place and these directions in place, your heirs in this moment of grief or emergency, it's hard enough to remain calm, but to have to make these highly emotional decisions, this goes a real long way in going ahead and laying out your desires there.
And can you imagine maybe having to go to court to get the right to make that decision when somebody's I mean it's so important, and actually in Georgia the healthcare directive is complimentary online. Make sure you don't go to a website that's trying to sell you one, but it is a complimentary. You may want help filling it out with an attorney or somebody that knows what they're doing, because the language can be a little legalese, right? But that is a document that is so important that it is available online, and I would encourage you to pull that down and get that filled out.
And then the next document kind of goes hand in hand with the Advance Directives. That would be the durable financial power of attorney.
Right. So this is another living document. In other words, this is a document that is used when you're still alive, okay? And it allows someone to make financial decisions for you. It allows someone to access your financial accounts to take care of you, whether, again, maybe it's a 2-week period, maybe it's the rest of your life where you can't make those financial decisions, whether it's because of memory or just, the health situation you're in. So that's, again, critical because, just because you may be a beneficiary of an account, you haven't passed away yet. So you can't get the money while the person's still alive. So you want the ability to be able, again, to go to that bank account, that IRA, to withdraw funds, to be able to either take care of you or keep the bills paid, keep the mortgage paid, things of that nature.
And if you're married, this is 99% of the time going to be your spouse, but also it's important to consider backups on these documents as well.
Absolutely. It could be a common accident. It could be a very short time between when maybe you need it for one and then you need it for the other, especially as we get older, into our 80s and 90s, more likely that, that kind of situation will happen. So you definitely want at least one good backup to that.
And not to go too far off topic, but this is a good opportunity to also say the need for immediate liquidity if something were to happen to your spouse. A lot of times if two spouses have separate checking accounts, maybe they're not joint or they don't have access to the other. Once someone is reported deceased, you don't have access until you have the death certificate, and then there's a process in getting access from there. So having joint accounts is really important with enough liquid money there.
And because the funeral home is going to want their money.
That's,
Unfortunately,
there's a lot of expenses right off the bat.
Yeah, and I don't want to be too funny, but it is Halloween, but you don't want to be kept on ice for 3 weeks waiting on some funds to come in or whatever.
And people say, we both have life insurance policies, really healthy death benefits, but those take time and you can't get that payout until you have a death certificate.
Which could be 3 to 6 weeks.
We saw a lot, recently we saw, 8-week process?
We saw one that was 4 or 5 months because they had to do an autopsy. And they were behind, and ever since COVID, they seem to be behind. So once you have to do an autopsy, that death certificate is not issued until after the autopsy is done. And I think with the client I'm talking about, I think it was about 5 months. She had to borrow money from her 401k at work to be able to get expenses paid.
Now I remember who I know you're talking about. Okay, so the next topic, if you're an adult with any retirement-specific investments, IRAs, 401ks, annuities, or any privately held life insurance, you'll likely need to designate beneficiaries for those accounts and policies. Very
important that you don't put down to your estate. If you list your beneficiaries as your estate, which sounds very simple and easy, now it's got to go through probate. And if you don't have a will, that's even worse. But even if you have a will, it's going to go through the will. And I tell you what, the beauty of having a beneficiary is it goes straight to that beneficiary. There's no holdups, there's no contesting of it, there's no waiting for probate. We've seen claims be paid out in 10 days to 2 weeks. And so make sure you have beneficiaries lined up. Don't assume either. In fact, with our clients, we do a beneficiary audit every 2 to 3 years because maybe it got lost. I mean, when you have mergers of insurance companies or banks or whatever, I've seen beneficiaries lost. And suddenly, if you don't have some kind of proof, then it's going to go through your estate again. So we do a beneficiary audit as things change, as wills get updated. Need to take a look at that as well if you end up getting a trust. having documents is very important, but having a plan around those documents, that's what we call an estate plan, making sure all those pieces work together. Do the beneficiaries match up with your wishes in the will and vice versa? Because again, the will's not going to control those beneficiaries. Make sure you have backup beneficiaries. And then you get into the concept of, let's say I'm leaving my life insurance policy to my 2 kids, and they have kids. So if one of those beneficiaries passes away before me, do I want it to go to their kids or to my other child? That's a specific language. And again, so you might need to get help with that. That's part of what we do as holistic retirement planners, is we help plan that estate, not just write documents. Now, we're not attorneys. We don't write documents, but we have several attorneys as part of our team. But we get together with the attorneys to get that plan together, make sure it all links into not only all of their accounts, but their entire retirement plan.
Absolutely. And we're talking about retirement accounts specifically right now, but that also goes for checking, savings, anything else like that that doesn't typically have a beneficiary, but you can put on there what is called a TOD, or transfer on death, or POD, payable on death.
Yeah, it's great. A lot of people don't realize this, but if you've got a checking account, if it's joint and you pass away, it's automatically going to go to the partner, the spouse. But the second passing, where does it go? It goes through probate. If it's a single account, again, it's going to go through probate. So add a TOD or a POD. You just go to the bank, ask for the form, fill it out, sign it, and now that money, if you pass away in your checking, savings, CDs, goes straight to that beneficiary. It's a beautiful idea. Many people are not aware of it. Very important that they know that.
Yeah. So the next step, if you're an employed adult with company benefits, you'll likely need to designate beneficiaries for those benefits. For example, most benefit packages have a modicum of company paid life insurance. If you don't name a beneficiary, no one will receive that benefit. It's unlikely and unfortunate that that's the case sometimes. Also, pensions, things of that nature. If you are receiving a pension or are planning to receive a pension, make sure that you have your beneficiaries set up on there if the pension has a beneficiary.
I think the most likely area that we see beneficiaries missed is on company accounts.
Yeah.
You join a new company and maybe you have a group health policy and either you don't think about it or maybe it only has room for one beneficiary. Well, you work for that company 20 years, maybe that beneficiary passes away, or maybe you divorce that beneficiary, and now there is not one on there or whatever, or maybe they're still on there. So be very careful with the company plans, whether it be group health, whether it be 401k, as you said, thrift savings plans, 457Bs, of course, all of those. Audit those every once in a while, make sure that they are correct.
Yeah. Okay, so I do want to take a moment to remind everyone to check out our website, masterplanretire.com. There are estate planning checklists. There's an actual checklist, step-by-step, what to do when a loved one passes. Mm-hmm. So these topics we're discussing today, we actually have resources that you can download and access on our website, masterplanretire.com. You can also schedule your complimentary consultation with one of our advisors to discuss your own retirement. Have a series of reports ran for you. That is a complimentary consultation, no strings attached, and at the very least you walk away with a lot of information on your own situation. So again, go to masterplanretire.com or call us at 770-980-9262.
You know the coolest thing about the website? With all the resources, with all the podcasts, with all the YouTubes, with all the checklists, there's this little green button. Mm-hmm. It says schedule a meeting. And you push that button and magic unfolds. My calendar pops up and you have the ability between Evan and I to schedule a 45-minute time to sit down and talk about whether it be your estate plan, but hopefully your entire retirement, dreams, goals, thoughts, fears, all of that. And then, like Evan just said, from that meeting, second complimentary meeting is a series of 7 to 10 reports. Let's find out where you're at. Let's find out, if you don't know where you are, you don't know how to get where you want to be. And so these reports will reveal that. So hope you take advantage of that.
That is the coolest thing about our website.
We paid dozens of dollars for that extra button.
Absolutely. All right, so the next topic, if you're an adult with any assets that don't have beneficiary designations, this could be vehicles, houses, land, valuables, things like that, you will likely need a will.
A will is, as I like to say to folks, it is a dead document until you die, right? So it doesn't take effect until you pass away, right? But at minimum, you need a will because, again, it's going to be up for grabs. You're going to have people coming out of the woodwork. Hey, Mark promised me his gun collection. Or Mark promised me his gold coins or whatever. No, I'm the favorite son. Whatever it may be. As I've said probably several times on these broadcasts, is you never really know someone until you share an inheritance with them. That's Mark Twain, by the way. I don't want to steal that. But it's true. We see it. I've seen station wagons backed up to houses during the funeral, ransacking grandma's house. I'm not going to say I've seen it, but I've been told about it during that week when it happened. So I wasn't across the road spying on them or anything like that. But yeah, it can get crazy. So at least a will. I mean, I don't care if if you're 25 or 30 years old, just want to get on and do one of those simple ones electronically. I don't recommend that if you have a lot of assets. But for at least to give some directions, you don't want to leave a mess.
Something's better than nothing.
Happens. Absolutely. Yeah. So very important to get that done correctly.
And again, a will is, even if you have lower assets, if without a will, you're still leaving a big problem for your heirs. Now, when you get into a higher asset level, and most people don't realize that they're in a higher asset level. Most people think, well, I think I need something simple like a will, but you may qualify for a trust. It just really depends on your own situation. Yeah,
there's no magic amount of money you need to have a trust. It's several different things we ask people, and then we'll guide them one way or the other. It's their final decision. We'll show the positives and the negatives for each one. But a trust certainly gives you more control, and I know we'll talk more about that in a minute, but at least a will. And also, you say, well, I don't have a whole lot of money, but do you have a spouse? Do you have kids? That much more important, for sure.
This is ultimately a conversation to have with your estate planning attorney and your advisor, but probate is, remember, wills go through probate, and probate is ultimately left to the judge's interpretation of your will. So keep that in mind as well. Sometimes that is all the push people need towards a trust as well.
Yeah, the first step in probate is, after filing, is the judge has to okay the will. Well, what if you missed? I saw a will recently that they scratched down something and initialed it. That judge could kick that will out. Because who knows if that's really, because it wasn't notarized after the change, right? So it's that judge is going to say, this is missed, this is incorrect, this language is complicated or fuzzy or whatever. It's not really clear. Or I'm not going to ride shotgun over all these wishes. Just split the money up and let everybody have it. I don't care about what they wanted here. So it's very important that you understand what probate is, and that way you can make a better decision about whether you want to avoid it or not.
Right. So the highest stakes estate planning need is for adult parents of minor children. It's through the guardianship provision in your will that you name those who will take on the responsibilities of raising your children. So through the designation of a trustee, your money can be directed to care for your children.
Right, so it's two pieces there. There's who cares for the children and who cares for their money. And many times it's the same person, but that's two things you need to make sure. So that money actually stays in trust until a certain age, typically 18, but you could change those wishes a little bit, but it's kept because a minor cannot inherit money. So you get somebody, a guardian, and by the way, if you don't name a guardian, the court will, okay? And so now, again, you've given up control, something maybe you did not want to happen at that point.
Yeah. Now, if you're a parent of adult children with assets, you may no longer need guardianship provisions unless your adult child is disabled. Now, that's another important consideration, but you'll still need a will to direct the flow of your assets, at least a will.
Yep, absolutely.
Now, once again, if you're an adult of significant means, in addition to your beneficiary designations, durable power of attorney, advance directives, and will, again, some form of trusts or trusts may also benefit you or your loved ones.
Yeah, so the powerful thing about a trust is a couple of things. Number one, it does avoid probate. Yep. Number two, it is a private document. Your will is not private once you pass away. It's filed at the courthouse. It's advertised, hey, Mark's gone, come get it, or whatever. A will can be contested. A trust, in most cases, cannot be contested. So that's at least some of the things. And people say, well, what's wrong with probate? Well, number one, it can be costly. Attorneys, if you need an attorney's help, which in today's environment, you probably do, they're charging 3, 4, 5, 6% of the value of the estate. Okay, so that's a pretty big cost. And again, it's not a private situation, and it can be contested. The will can be thrown out for various reasons as well. So the trust avoids all that. The trust doesn't go to the courthouse. Nobody knows what's in the trust except those that have a copy of it. That would be the trustees and maybe beneficiaries, but even the beneficiaries aren't privy to the copy of the trust. And so it is, and it's also something that you can actually spread your estate out over a number of years. So, maybe I don't want my 2 kids inheriting, $10 million all at once. Maybe they're great kids. Maybe it's because if they inherit that money, they get into a lawsuit. Maybe they get into a divorce. It's subject to that. So there's other reasons to spread it out over time, tax reasons as well. So that might be something that would fit you. Again, these are not recommendations. We are not attorneys, but we do work with these items every day, and we can see the power. And we have clients pass away, and we see how these documents work as well. And that's why we are so careful about making sure everything's in order. Every second or third year during our annual review, I go back and we look at the documents together to make sure nothing's changed, things of that nature as well.
Yeah. And there are other add-ons or nice-to-haves that could complement your estate plans, but these documents mentioned are virtually vital for all these situations that we're discussing.
Yeah, absolutely. And there are special trusts out there to help avoid estate taxes and maybe to save taxes while you're living, charitable remainder trust. I mean, there's a dynasty trust. There are a dozen trusts, an irrevocable trust to help avoid estate taxes. These are for folks that typically are up in the millions of dollars, okay? But those are things that we deal with every day as well.
But we also mentioned the parents of adult disabled children. There are trusts.
Special needs trusts are very important. You don't want a special needs adult child that maybe is on special programs.
And again, that's not asset based on the parent.
No. And so if my special needs adult child who's on Social Security benefits, maybe they're on Medicare, Medicaid, these are all based on them having a certain amount of money. And if they suddenly inherit $100,000, $200,000, $1 million, or whatever, then they're going to be kicked out of those programs.
Right.
So that going to a special needs trust, it does not belong to that special needs adult, but it can be used for their care. And so again, just sometimes what we don't know, as we've said many times, is the thing that will come up and bite you. So that's why we do these shows, is to hopefully inform you as to what to look out for.
I do want to disclaim that we are not estate planning attorneys, and nothing that we've shared should be construed as legal advice. However, we as financial advisors are trained in estate planning and responsible to offer direction. This is because our charge is not simply to help you maximize your net worth, but also to work to optimize its utilization. The options for planning after your death are sorely limited, but during life, they are only limited by the law and by your imagination.
I think with us, Evan, it comes down to making sure we know what those parents want. We've worked with them for years. We understand they want to enjoy their retirement, but they also want to maximize what their children, grandchildren receive, maybe build a legacy. And so, again, do you want to waste your money on probate? Do you want to waste your inheritance money on paying too much in taxes? Part of that, and again, do you want to leave a mess for your children and grandchildren as well? So it's really important, and it's just part of what we do. Again, with a holistic approach, we're covering all these areas, and this is an important area, and I'm glad we talked about it today.
Yeah, important area that potentially causes the most stress beyond just the client, but the heirs and the next generation as well.
Yeah. And don't be afraid to face it. I mean, we none of us are immortal. Just be prepared.
Yeah, absolutely. Yeah. That brings us to the end of the day. Mark, any closing remarks?
No, just appreciate you watching and listening, and plan well and prosper. Take care.
This was Retirement Roadmap Radio with Mark Fricks of Master Plan Retirement Consultants. To schedule a complimentary consultation, go to masterplanretire.com or call 770-980-9262. Thanks for listening, and remember, Plan well and prosper.
All matters discussed during this show are for informational purposes only. Each individual situation may vary, and the opinions expressed here may not apply to everyone. Materials presented are believed to be from reliable sources, and no representations can be made as to its accuracy. All ideas and information should be discussed in detail with one of our qualified representatives prior to implementation. Advisory services offered through Master Plan Retirement Consultants, a registered investment advisor in the state of Georgia. Mark Fricks and Master Plan Retirement Consultants are not affiliated with or endorsed by the Social Security Administration or any other government agency.